Okay, in note 7, we begin a discussion of employment and the relationship between employers and employees. Um, Going back over 100 years ago, well, actually not even 100 years ago, going back 80 years ago, before the Great Depression in the late 1920s and throughout the 1930s, um, employment was seen as a contractual relationship between the employee and the employer. There was very little interference or very little regulation on the federal level, almost none at all, and some regulation on the state level, but really not a lot of control. The relationship was left between the two parties themselves, and now, before the industrialization of the United States, which began around the time of the Civil War in the 1860s and then proceeded dramatically throughout the 1870s, 80s, and 90s. Prior to that time, most companies, most types of employment situations were small. There'd be a few workers working for an employer. They would have direct dealings with whoever were the principals in the business. They would negotiate their wages and their working conditions. And they were felt to and seen to be by the law and by the state and federal government to be two parties on equal footing, entering into agreements, entering into contracts. If the employee didn't like the way they were being treated, they could leave and find other employment. If the employer didn't like what the employee was doing, they were free to terminate their services and send them on their way. As industrialization took place, as large corporations began to develop, particularly beginning with the railroads and then moving on into the steel industry, the oil industry, as these developed, there became a great disparity between the power of the employees and the power of the employer. The employer, of course, having a great deal of power and control, and the individual employees being rather on their own and not able to control or deal with situations except to do whatever their employers wanted them to do. This began with the early textile mills that were created throughout the early 1800s, but again, became particularly true as we got to the late 1800s, early 1900s, and other large industries besides textiles began to develop. Large factories were created, working conditions were brutal, hours were long, the number of days of a week that you had to work were long, and the state and federal governments largely stayed out of this, although by the beginning of the 1900s, the states were trying to do things, but very often they were thwarted by the courts, who also took the position that these were contractual agreements between employers and employees, and that it was not the government's job to help the employees. Now, most employment, even to this day, is considered employment at will. An at will type of contract, and all employment does involve a contract. Those of you who have studied contracts should be able to analyze it. You have offer and acceptance, you have consideration, you have legal purpose, you have the capacity. The different elements that are required to create a contract are present in an agreement to work for somebody, to work for an employer. So, in a contract at will, they're kind of different things if you haven't encountered them or thought about them before. It's a contract that has no particular endpoint and can continue in time until either side decides, no, it's done, it's over, and they want to terminate it, or it becomes terminated because of some outside event such as death or illness of one of the parties. It is a real contract. All right, the courts have long held there are at-will contracts in employment, there are at-will contracts in renting and leasing of real estate and property. One of the things about an at-will contract is that you need no particular reason to terminate. As long as one side decides, I no longer want to do this, they have the power to end the agreement, end the contract, and it is over, even if the other side would have wished to continue. Again, in Rhode Island, in Massachusetts still, 90% of all employment is employment at will. The agreement exists so long as both the employee and the employer want it to exist, and as soon as either one of them wishes to leave, wishes to change it, wishes to stop it, then it is over. Now, there are a few exceptions to this. One is if you have a agreed employment contract for a set period of time. If you're a member of a union, the union spends a good deal, the union representatives spend a good deal of their time and effort negotiating periodic contracts for 1 or 2 or 3 or 5 years, and you can only be fired during that period of time according to the terms of the agreement itself. If you are following all the terms of the agreement, then you cannot be fired. Many executives in companies, when you get into the higher management positions, they have employment contracts. They have a set period of time that they are hired to work for the company. The company can always renew it when the set period is over, but during that period of time, the company cannot fire them without cause, nor can they leave unless they're leaving fits one of the contingencies of the agreement. This is done very often with executives because the corporation wants to control them in certain ways, and as part of the employment contract, besides having a definite salary and a definite term for which it will run, they include things like provisions to preserve secrets, provisions to prevent the employee from going to work for another employer in the same business, provisions to keep client lists and client information confidential, so that there are a number of reasons why, particularly when you get up into the higher echelons where people are dealing with trademarks and patents and trade secrets and client lists and inside information of corporations, it behooves the corporation to have a set contractual agreement. There are issues if a employment agreement is wrongfully terminated. So even though you have an at-will situation where you need no reason to terminate, if the employer accuses an employee of some type of malfeasance and uses that as a basis for termination, they can still be sued. Even though an at-will situation would seem to say that they can stop the employment at any time. There are public policies. There are state laws and some federal laws that have to do with what's called being a whistleblower. We'll get into that in a little more detail as we get further into this note. But the idea is that for informing on illegal activity, for informing on dangerous or wrongful activity, the employer cannot take retaliation and discharge you for that. Wrongful discharge is a situation where, again, the employer trumps up a reason for firing you, and this is a tort that in itself the employee can sue, and particularly if the employer goes ahead and then proceeds to give bad recommendations or to say untruthful things about the employee to other employees or to clients or to customers of the company, then the employee can also sue for slander and libel. Okay. Beginning particularly in the Great Depression, when more than 25% of the people in the country were out of work and the economy had hit the skids and was in extremely bad shape, the federal government began doing all types of things to try to get the economy going, and as part of this, they began to, for the first time, to seriously put their hands and put their noses into the relationship between employers and employees. Now, if you read anything about the history of the Great Depression, Franklin Roosevelt became president early on in the Depression. He was president for 4 terms. He served not the full 16 years because he passed away in his last term, but he served a good 12 years while the Depression was running, and he basically came up with a program called the New Deal to try to use federal power and federal regulations and federal statutes to get the country going again and to make conditions better for the people who were in great need and desperate circumstances throughout the country at that point in time. This did not come without a fight. The Supreme Court was at first very, very reluctant to let the federal government start interfering in this sacred idea of the contract between employer and employee and the free will of free rights of each of them to enter into whatever agreement they wanted. But eventually, the court, after being threatened with adding more justices to the court, and particularly ones that would be friendly to Franklin Roosevelt's programs, the court relented and allowed a number of these things to take place, to become law, to not strike them down for constitutional reasons, and a whole revolution in how labor and employers deal with each other began. Part of this package of laws was something called the Fair Labor Standards Act, and it created a number of things. There were a number of different components to it. There could be no labor under the age of 14 unless you were involved in a family business. No hazardous duty for anyone under 18. It established a minimum wage, which today has gone up to $7.25 an hour, or $2.13 an hour if you work in a job where you get tips directly from the clients and the customers. But it set a base federal minimum wage, which had not existed prior to that time. It stated what a work week would be: 40 hours per week, only up to 8 hours a day, and after that you would be entitled to time and a half for your wages. It basically allowed for employees for the first time to have rights against their employers that could be enforced by federal regulatory agencies that were set up, and that could be bring the power of the federal government to offset the power of the large corporations in which most people were employed by the time of the Great Depression. Some of the things that have come lately is that layoffs, the government has to be given 60 days notice of mass layoffs, although smaller layoffs do not require such. In 1993, the federal government passed the Family and Medical Leave Act, which allows for up to 12 weeks for a newborn baby, the adoption or arrival of a foster child, spousal illness, employee illness, or medical emergencies of the employee. The employer must maintain health insurance during this period for the employee, and they have to restore the employee, once they come back to work, to their former position and former pay level. There are exceptions for key employees whose position has to be maintained, and whose spot cannot be kept open for 12 weeks without causing great harm to the corporation. However, many states have also passed laws paralleling this and that are even stricter than the federal laws, as they have with the labor relations laws. Many states have higher minimum wages, and they have stricter rules and regulations for the federal government, and the Supreme Court and Congress has allowed that to happen so far. The federal government in the 1970s passed something called OSHA, the Occupational Safety and Health Act. This was established to try and make dangerous industries, dangerous jobs less dangerous, and to provide federal oversight, to create rules and regulations that will determine what is safe and what is not safe in the area of working, and particularly in industrial type working, or construction type working, where it's very easy for employees to become injured. Under this, OSHA has the power to create standards and regulations that have to be followed. They keep track of every injured employee, and they have the power to enter and inspect any work site without a warrant to determine that the rules and regulations are being followed. And failure to follow these rules results in fairly heavy fines for the employer. Workers' compensation came into being, again, about the time of the Great Depression, although some states had had it a little bit earlier, going back into the 19 teens and 20s. But it really didn't become widespread throughout the country until the Great Depression came and all the other changes were being made in the relationships between the federal government, employers, and employees. Um, Workers' compensation laws are by and large state laws at this point in time, and they modified the common law. At common law, employees face incredible obstacles to recovering for injuries that happen to them while they're on the job. First and foremost, an employee would have to try and hire a lawyer to go up against this huge corporation or huge industry that they worked for, and very few lawyers were willing to take that on in the early years. They weren't willing to take it on even for what we now have today, where a plaintiff's attorney will take a contingent fee and will take the case and only be paid if they won. The rules were so stacked against employees, they had very great difficulty suing, and they, of course, couldn't afford to hire lawyers on an hourly basis. Other types of rules. If a fellow employee injured the employee or was the cause of the injury, then the employee was not allowed to sue the employer. They could only go after the fellow employee, who, of course, had no money, the same as the employee. There was nothing to get. If the employee was in any way negligent for their own injury, then the tort laws at the time said that if you were contributorily negligent to your injury, you could have no recovery. So there were many, and there were other rules beyond these. Those are some of the most flagrant ones and most visible ones, known ones. But there were many reasons why employees were unable, once they were injured or if they were killed on the job, their families were unable to recover against the employers. So what happened is the states modified the law by statute. They basically changed the common law. So today, if you are injured at work as an employee, now these don't apply to independent contractors, but these rules apply to employees. If you're an employee and you are injured at work, you have no right to sue in tort. You have no right to bring a negligence action against the employer. Instead, your case is now under the rules of the Workers' Compensation Court, and they have set rules and procedures and amounts of money that can be recovered by the employee for an injury sustained at work. This may seem unfair. However, what has happened is because these are no longer tort cases, you do not have to prove that the employer was at fault, that just the mere fact that an injury happened while the employee was on the job allows the employee to recover. So all the rules about contributory negligence, about assumption of the risk, about fellow employees, those have all been thrown out. And if you are injured at work, regardless of how it happened, if you did it to yourself, your employer is still responsible, and under the workers' compensation laws, you have a right to have your medical expenses paid. You have the right to recover a certain amount of pain and suffering, but nowhere near what can be recovered in the civil courts in a regular tort case. And you have a right to have a continuation of money coming in while you are injured until you can go back to work. In Rhode Island, employers of 2 or more people must have insurance to cover any worker-related injuries. There are several unemployment, workers' compensation insurance companies in the state. Failure to have this coverage by statute now results in piercing the corporate veil. So even if you as an employer set up a corporation, a business corporation or an LLC, and you have 2 employees, you have to be very careful, because if you work in the business yourself, very often the courts will count you as the first employee, which means that as long as you have 1 employee, you're now under the workers' compensation laws. And if you fail to have insurance in place, the corporate veil will not protect you. The employee can now go after your personal assets, but not under tort law. They would go under your personal assets under the workers' compensation rules, which means they don't have to prove negligence against you. They only have to prove that they were injured on the job, and you will become liable for their medical expenses, pain and suffering, and for giving them an income during their period of disability. One of the greatest issues I have with clients starting new businesses is to make them understand the seriousness of the workers' compensation laws and the results of what happens if they don't get workers' compensation insurance, but they have people working for them. And again, we've seen in the cases where employers will do anything they can. They'll create a ream of paperwork to try and prove that somebody is an independent contractor, which means that person doesn't come under the workers' compensation rules. However, if the facts of the situation are that they control this person and this person basically does activities like an employee, then it doesn't matter what they have signed, what they have agreed to, they are an employee and they fall under the workers' compensation rules. Okay. Another huge program for employees that was enacted during the New Deal, during the Great Depression, was the creation of the Social Security Administration and Social Security benefits. Every employee is taxed. They take out somewhere over 6% of your income up until a certain threshold, which is above $100,000. And the employees have to contribute that from each paycheck. However, the employers must match the employee contributions. If you are disabled, or once you reach the set retirement age, which is now up to age 67, then you can apply to collect Social Security benefits. So this provides an income for people in their later years when they can't work or if they are disabled to such an extent that they cannot return to work. You might hear people talk about COLAs when they're talking about Social Security. This is something that the federal government instituted a number of years ago, probably about 30 years ago now. It's an acronym for Cost of Living Adjustment. As the law now sits, every year the Department of Labor must determine if there has been inflation, and if there has been inflation, then all the Social Security benefits of people who are collecting Social Security will go up based on the percentage of the increase of costs throughout the economy. Very critical thing because inflation has been running at a fairly decent pace for the last 30 or 40 years. And even at 2 or 3% a year, after 10 years, that can take 30% out of the earning power of a pension amount. And what happens with Social Security, the amount that you're going to receive is based on your employment history, based on how much you had contributed, based on what your wages were while you were working. And at the time you apply for Social Security, they set an amount that you are to receive each month for the rest of your life. And there is no real appeal to that unless they've made a mathematical mistake, but it does not depend on what you need to live. It depends on what your working career was. And for many people, the only way that that can increase over time is through the COLAs that have been now provided by the federal government. There's discussion in Congress all the time about getting rid of the COLAs, but very few politicians want to take on the AARP and other senior groups who they would have to fight in order to do that. In the 1960s, the federal government enacted a program called Medicare. Medicare is a government health insurance program for senior citizens. And again, during your working life, both employees and employers pay a tax every time you receive a check or a direct deposit for your salary. You have to pay into Medicare, and that is there. So again, if you become disabled or as you get older and you're collecting Social Security, you can also receive this government health insurance, which is far cheaper than paying for private health insurance in the private sphere. There are private pensions. A pension is basically a fund where the employee will pay in. Very often the employer contributes equal amount, or sometimes more, sometimes less. And all this money is supposed to be going into a fund so that, again, when the employee reaches an age where they no longer can or don't want to work, they can now collect an income for life from the pension. For a long time, these were not controlled, and many people worked many years, paid into pensions. The company would go bankrupt, would close, would move out of state, would fire the person a month or two before they were ready to retire, and they'd end up collecting nothing. So again, in the 1970s and 80s, the federal government moved into this area big time. There's a law called ERISA, E-R-I-S-A, and it basically deals with controlling these pension funds to ensure that employees are protected. So it requires that private employers pay money into these funds to make sure that there'll be money there. It requires that these funds be segregated and separated from the corporation's ongoing assets. And if the corporation goes into bankruptcy, these funds are not part of the bankruptcy. They're extremely complicated statutes. The lawyers who deal in this basically almost specialize in these things alone. Under this type of system, they also set up the various things that we have today, IRAs, 401ks, 401bs, various plans where the employers can move away from these pension funds per se, but they can allow the employees to set up accounts that the employers, again, can contribute to and the employees contribute to. They are not taxed at the time money is put into them, but when the employer retires and begins to withdraw funds to live on, then they are taxed. The idea being that you'll be making a lower income in your retirement and your tax rate will probably be lower. An important concept to understand if you ever work for an employer who has a pension fund, and even if you're dealing with a union pension fund or a state or municipal employee pension fund, is a concept called vesting. Vesting is the point when an employee has met certain conditions involving length of employment, full versus part-time employment, the amount of income and contribution, job performance, satisfactory job performance, that at that point the employee will be deemed to have an irrevocable right in the retirement plan. Now that may not mean that if they retired the next week they would get a full pension, but they have a certain right to the funds that are there, and they would have a certain right to collect on that retirement if they became disabled or when they retire. So that's a very important concept. The requirements for it can change from company to company, from entity to entity. So when you go to work for a company that has a pension program, very important to discover and to learn what those rules are early on so you are not surprised. All right, one thing to keep in mind as you go forward in your lives, federal employees, state and local employees are not subject to ERISA. There are federal pension programs, there are state pension programs, there are municipal pension programs for the people who work for those various agencies. They do not come under this law. State and municipal pension plans, because of the 11th Amendment giving the state certain rights that continue even to this day against the federal government, the state pensions are generally not controlled by the federal government's rules. And so if you ever work for any of those agencies, again, you need to become familiar with what are the rules, what are the requirements, what are the pension plans involving those different agencies, different folks. Many employees in our system, many people in our system, get their health insurance coverage through their employers. It's a very interesting thing. This is almost unique in the Western world. Most other Western countries at this point have some form of socialized medicine where the government basically is the health insurer for all, and where basic health coverage is given to citizens and residents by the government regardless of what your employment is. But there was no such thing as health insurance in the United States, again, until just about the end of the Great Depression. And one of the things that happened is the end of the Great Depression came when World War II began. And once we became involved in World War II, after the attack on Pearl Harbor, there was a tremendous growth in industry as the government began borrowing money and paying all kinds of money to ramp up the war effort, to build tanks and trucks and planes and bombs. To keep prices and things from going crazy during wartime, because there were shortages of almost everything, gasoline, fuel, food, raw materials, as everything was being taken to support the war effort, to support the military, to keep prices from going crazy, to keep people from gouging. What happened is they passed very severe laws limiting what wages could be, what prices could be. All of that was regulated and controlled. Um, Employers had a very difficult time. There were more than 10 million people in the service during World War II, and that's in a country where there were only 130 million people at the time, as opposed to the 360 million people that live here now. So there was close to 10% of the entire population of the country was involved in military service. Made it very difficult to get employees, and because of the wage and price controls, you couldn't offer them higher wages to lure them from one business to your business. So what employers began to do was they began to offer forms of health insurance coverage. Well, over time, this became so popular that it grew greatly. The unions began to jump in and become involved with this, and demand that their employees, their union members, get health insurance from the employers. And over time, by the time we got into the 1970s, the vast majority of people in the United States who had health insurance had it through their employers. There were all kinds of rules and restrictions, and it was very severe. Some of them, if you left one employer and went to another, sometimes you could wait up to a year before you'd be be reinsured by the new employer's company. Very often they had rules for things called pre-existing conditions. So if you had developed diabetes or cancer or heart disease while working for one employer, and then you wanted to switch to another employer, the insurance company for the new employer could exclude anything for which you were already ill, which kind of defeats the purpose for having the insurance. These activities became so restrictive, became so corrupt, that in the 1980s, the federal government passed a bill that we call COBRA, C-O-B-R-A, and basically it created a whole series of regulations determining what happens with your health insurance if you leave an employer. And one of the basic things, major things about COBRA is that even if you are fired, if you are laid off, you have the ability, if you can pay for itself, to continue your health coverage for a period of time and continue on your former employer's insurance. Coming into the 1990s, another law called HIPAA was passed, which added certain things such as getting rid of pre-existing conditions if you switch employees. As long as you can show you went from one employer to another without a break in employment, the new employer's health insurance has to pick you up. And of course, the Affordable Care Act, or what people in slang call Obamacare health insurance, was passed in the early 2000s under President Barack Obama, and it basically requires, for the first time, that an employer over 50 people has to have a health insurance program, has to give some kind of coverage to their employees. And it basically sets up a system where just about anybody in the country can buy into health insurance if they wish. All right. Privacy rights of employees. The basic reality about employee privacy rights is that you do not have any. They are very, very limited. An employer can monitor their employees. They can set up cameras. They can set up sound recording systems. They have the right to check your computer usage, internet usage, to see what you're doing on the computer. They have the right to drug testing. They can require periodically that you submit to drug testing, and particularly if you are handling heavy equipment, large tools, instrumentalities that could be dangerous, there's almost an absolute right to test you. Public employees have a little bit more protection here because the 14th Amendment, Bill of Rights, is said to apply to the governments in ways that it does not apply to private employers. So municipal and federal government employees have a little bit more protection, but even so, basically you have the right as an employer to require drug testing, and your employees cannot refuse. They can be fired for a refusal. Most states have at this point outlawed giving lie detector tests to employees or requiring genetic testing of employees. So you might wonder, why would you do lie detector testing? Of course, it would become important if you felt an employee was not telling you the truth about something that had occurred. Why would an employer want to do genetic testing? Well, if the employer is paying your health insurance, knowing what genetic conditions you may be subject to could be a great benefit and would allow them to not hire people who they fear might in the future have serious health conditions that they would have to cover under their insurance. Most states have made that illegal by state law. There are no particular federal regulations on either of those at this point in time. Now, immigration and employment come smack head to head against each other based on the system of immigration and the immigration laws that we presently have. The basic reality is that if you do not have a green card, if you are not in an approved status as a legal resident, either a permanent one or for a specific period of time or for a specific job, you have no right to work in this country. You may come here as a visitor, you may even come here to stay, living with a friend or a relative who's willing to support you, but you have no right to work. These rules, of course, are sometimes enforced, other times they're not enforced. One of the great arguments over the last 15 years has been how do we deal with the illegal immigration to this country with non-documented people. Estimates are there anywhere between 11 and 20 million non-documented people in the country at this point in time, and obviously a large number of them are working somewhere, somehow they are getting paid. Now, as an employer, under legislation that was passed in 1986, every time you hire a new employee, you must establish their identity and their citizenship or resident alien status. A resident alien is somebody who, in slang, we say has a green card. It means even though they're not a citizen, they have been given permission to legally reside in the United States, and therefore they are allowed to work, and they basically have all the same rights as a citizen would have when it comes to employment and dealing with the law. An employer has several forms that they must fill out. They must have documentation presented to them by the employee, such as a Social Security card, which is only supposed to be issued to citizens and to legal residents. Birth certificates, passports. The employer, before allowing a new employee to take their position, has to collect this documentation from the employee, has to keep track of it because the federal government, immigration, or ICE has the right to come in at any point in time without a subpoena and ask for the records to see if the people who are working for this employer are here legally. And there are fines and even jail sentences that can be imposed upon an employer if they are hiring people who do not have the right to work here. There are certain types of visas. A visa under the immigration law is a special permission to come into the country. One of the most largely obtained types of visa is a visitor or tourist visa, where basically someone who's not a citizen of the United States, does not reside here, wants to come here, has to go to an American embassy or consulate, present their paperwork, present their passport, and obtain written permission to come to the United States for a particular purpose, for a particular period of time. Other types of visas. There is something called an H-1B visa, which has been greatly complained about in recent years. Under an H-1B visa, an employer can ask the federal government to allow certain types of workers, trained workers, to come in from other countries on this specialized visa on the theory that they cannot find Americans who will fulfill this job, that there are not enough people here to do this. The idea here is that the country needs to keep running, it needs to keep working, it needs to have jobs fulfilled, industry needs to keep going. If we can't find Americans to do these jobs, then we will bring in qualified people from other countries. These are supposed to be temporary visas that once the need is over, or once that particular job is over, then these people would have to return home. They do not get permanent resident status just by getting an H-1B visa. Now, these have been subject to tremendous abuse in recent years. Theoretically, the companies are supposed to pay H-1B visa holders the same rate of pay as they are or would pay Americans, and that does not always happen. They're only supposed to stay between 3 or 6 years. Those limits are not always enforced, and the employer is supposed to make sure that there are no workers in the U.S. who could fill this job. Um, it is absolutely apparent if you just look at any industry, particularly in the tech industries, computer programming, computer operations, computer repair and maintenance industries. Um, the American corporations have been bringing in large numbers of people from overseas, claiming there are no Americans who would want to do these jobs. They bring these people in. They very often do not give them the same working conditions or the same salaries as Americans would receive. But because these people are here in these special visas that require them to maintain their employment to stay, they're very much captive, because if they complain about the employer to immigration, the employer can tell immigration we don't need them any longer, and then their visa is gone and they have to leave. So it's really an unenviable situation. There are many, many hundreds of thousands of workers here, particularly from China, from Hong Kong, from India, where people have the ability to go to school for free, to obtain advanced degrees, again, particularly in the computer sciences and other technical areas, and where companies happily file to bring them in, go through all the paperwork, make it look like they can't find Americans to handle these jobs, and the race is then on. H-2 visas for agricultural workers. We still have what in my time, 40 years ago, were called migrant laborers, migrant workers. If you are raising crops, many, many crops are such that all of the produce ripens and becomes ready for picking and ready for packaging and shipping all at once, so that you've been working all year to produce a crop of a certain item, particularly with fruits, and you have to get these things picked quickly, stored, and put in refrigeration or whatever chemicals, whatever is used to keep them. And if you don't get them out of the fields quickly, then you will lose large parts of your harvest. So from time immemorial, there have been migrants, particularly from Mexico and from some of the Caribbean countries who come in at harvest time, and they will travel around from farm to farm, from agricultural installation to agricultural installation, doing the harvesting, doing the picking of the crops. And of course, when that's done, they're not allowed to stay on these visas. They would then have to go back home, and if they can get the visa again, they would return the next year to do it again. So, and even though we are highly mechanized at this point in time, even though large parts of agriculture operate with very few people, far fewer people than they did 100 years ago, there are certain types of fruits, certain types of produce that can still only be picked well by hand, that they have yet to figure out ways to mechanize the systems to produce a high quality product, and therefore we bring in these workers for periods of time each year to work, and then they have to go back home and wait for the next year to come back again. And again, getting this type of visa does not guarantee you or even allow you necessarily to apply for a permanent residence visa. It's a very different type of thing. You can get visas for managers of foreign companies that have facilities in the United States. You can get an investment visa. If you are willing to invest more than $500,000 in a United States business, then you can get a visa to come in and start your business. You must bring your money with you, and usually that means you and your family members, at least immediate wife and children, get to come in, and you actually get a green card at that point. You're allowed to become a permanent resident. And of course, there are student visas. Many millions of students come to the United States every year to attend our universities, and they receive student visas that are only supposed to be activated and work for the time that they are studying. In 2020, there's been a great outcry coming, because with the schools having shut down for the COVID-19 virus, and many of the schools not going to on-site learning come September. The Immigration Service announced that any college or university that did not have on-site classes, their foreign students would not be granted student visas for the coming year. They would have to stay in their home countries and do their internet or distance learning from their home country. And as we sit doing this video at the moment, they still have not resolved that question. It's still being argued and fought out about in the courts and before the administrative agencies, before ICE. Again, it is a very, very difficult issue. It has been very contentious under President Trump's presidency, and even before that under President Obama. The idea of the fact that there are millions of people who have come into this country and they are here illegally. They don't have permanent resident status. They are here, but they are undocumented. They do somehow find jobs, and this comes up over and over again as an issue. And the federal government, on one hand, seems to get all uptight and upset about it. We'll do raids, and we'll deport people. But then on the other hand, they have allowed, as we said, anywhere between 11 million and 20 million people to reside in this country who do not have credentials, do not have the paperwork to allow them to legally be employed. And again, this creates all types of situations, because if you are an undocumented person and you do somehow find a job, either by having false papers or find somebody who's willing to hire you and not turn you in, you run the great risk of being discovered and fired, or of, if you try to cross your employer, if you complain to your employer, being reported to ICE, which is Immigration and Customs Enforcement Services, and being deported. So it creates a very difficult and nasty low-wage employment situation for these people. All right, I'm going to stop here, and we will do 11.2, which gets us into talking about unions.